And recently we have seen that the Supreme Court of India has launched a tool which is by the name SUPACE, which is Supreme Court Portal for Assistance in Courts Efficiency. And this tool is based on artificial intelligence, artificial technology, and also machine learning, which actually helps the judges to collect the relevant facts and laws related to the case. And also we know that online dispute resolution using technology and techniques is actually strengthening the alternate dispute resolution processes like arbitration, mediation, and negotiation. And many countries like Singapore, Australia, UK, US, they have benefited from ODR by reducing dependency, also increasing access, and at the same time saving costs. So in order to understand the nuances of using technology in the justice delivery system, PhD Chamber of Commerce Industry has curated this very important webinar on justice technology need of the hour. And since we are the domain experts, the distinguished experts who are basically, the dons in their own ways in terms of, giving big judgments and also using technology. So without any further ado, I'll request our chair of the committee on the forum on New Delhi International Arbitral Institution, Mr. Kuber Diwan, to kindly start the proceedings with his welcome address. Over to you, Mr. Diwan.
Thank you, Dr. Singh. First of all, a very good evening and a very warm welcome to all. It is my pleasure to welcome all the distinguished speakers on this fine evening. I would first of all like to welcome Honorable Mr. Justice Sikri, former Judge of the Supreme Court of India, Honorable Mr. Justice Navaniti Prasad Singh, former Chief Justice High Court, Kerala High Court, Mr. Raman Agarwal, who is the CEO and founder of Jupitice Justice Technologies Private Limited, my co-chairs, Mr. Rashi Dheer and Mr. Bhuvnesh Sehgal, and of course, Dr. Jatinder Singh, the Assistant Secretary General, PhD CCI, and his team, our event sponsor, Jupitice Justice Technologies Private Limited, our other distinguished delegates, friends from the media, and ladies and gentlemen. I'm pleased to extend my sincere thanks for everyone who has joined us today for this webinar on justice technology, the need of the hour. The topic for today's webinar is both interesting and relevant in the Indian context. Ensuring easy, accessible, cost-effective, and speedy justice are the prime motives of the Indian judicial system, which is currently overburdened by a huge pile of over 4 crore pending cases before various courts, with thousands more adding each day. As we see that new technological tools have evolved over time supporting alternate dispute resolution or ADR mechanisms in facilitating out-of-court settlement of disputes, the digital justice delivery system introduced the online dispute resolution or ODR mechanism. The whole process uses technology and cyber network and has proved to be significant in eliminating physical presence, providing access to judicial procedure at one's own doorstep. Justice through technology is a pioneer innovation and a giant leap towards guaranteeing accessible, speedy, and cost-effective settlement of huge volumes of pending as well as new disputes. But like any other system, this will also have its pros and cons. And for fulfilling its desired motive of ensuring easy, accessible, speedy, and cost-effective justice for all, it must evolve in such a manner that lack of infrastructure, including internet, not having a proper environment suitable for judicial proceedings and data protection, etc., do not hinder its growth and usage. Today's deliberation will touch upon subjects like usage of technology in India in the judicial system vis-a-vis other countries, steps taken by our government and courts for improving the justice delivery using technological advancement and better tech infrastructure, future prospects of ODR, and how it has the potential in making life of a common man easier, the current position of technology infrastructure in India, and what should be done to improve it. As we all know, the ongoing COVID pandemic and its resultant lockdowns have impacted almost all spheres of society, and the legal system is no exception to this. The already overburdened courts are facing an outburst of new cases arising from this global epidemic. With the courts not being able to function to their full capacity and forced upon a lockdown to avoid much needed non-physical proceedings, the time has come for justice delivery system to adapt to the new normal, that is virtual justice delivery, by inducting wide use of technology. This is not just in case of India, but it's more of a global phenomena which almost every country is bound to accept. This is when the ODR as a tool can be a game changer in not only providing a quicker and cost-effective justice delivery system, but will in the long run share and reduce the burden of the Indian courts. We must understand that e-courts and ODR are not only confined to COVID era, but is actually here to stay. The courts have already started e-filing of cases, virtual hearings, and ODR has further extended it to witness examination as well. System is getting used to this new normal and is benefiting from it. Though Indian courts have been using technology for quite some time now to access the case status, judgments, display boards, etc., but what the system is looking for is a full-fledged technology-based infrastructure which the Indian judicial system has lacked till date. Technology-based judicial system has multiple advantages. It is speedy, as it will save a lot of wasted time, which is wasted in filing and in the documentation process. It is more cost-effective, easily accessible, as there is no requirement of physical presence, and ensures transparency. But there are definitely hindrances that stop it from gaining the popularity it was expected to achieve. These hindrances include lack of knowledge of computers amongst the common man, lack of infrastructure, absence or inadequate internet, lack of trust towards a new system, and fear of data breach, etc. In today's webinar, we will try and deep dive into deliberating the various aspects of a digital justice delivery system, including providing a platform for the stakeholders to interact and discuss about the various aspects with respect to the usage of technology for justice delivery, especially in the Indian context. We also aim to create awareness amongst our various stakeholders to have a better understanding about the importance of technology and technology platforms for easing the burden of the Indian judicial system in the coming times, and to promote collaboration between different players from this domain for facilitating innovative ideas leading to technological development best suited for India. I once again thank all of our domain expert speakers who have spared their precious time to share their views and experience with us. Thank you, and I hand over to Dr. Jatinder Singh to take this forward.
Thank you, sir. Thank you, Mr. Diwan, for laying the foundation of this very important webinar. And in brief, you have given in the context of this webinar and how things will unfold. I am sure that our distinguished panelists will actually throw more light on this. Now, I'd like to invite Mr. Bhuvnesh Sehgal, our co-chair of New Delhi International Arbitral Institution, PHTCCI, to kindly give the theme address. And I will also request him to kindly moderate this session. Over to you, sir.
Good evening, everyone. Good evening to the distinguished speakers. Mr. Kuber Dewan has deep dived into the entire crux of today's seminar. I should not be wasting more time, and I should let Mr. Amir Z. Singh Prasad, who's our first speaker, to open up. Mr. Prasad is a commercial lawyer with a wide range of experience in contentious and non-contentious work, and has practiced in India since 1992. He is now primarily involved in commercial disputes and arbitrations. He's the managing partner of ILA Prasad and Company, a firm that he founded in 1998. He has been involved with international and cross-border work, having chaired the International Sales Committee of International Bar Association. He is now a member of the IBA's Legal Practice Division Council. He has been recognized individually by Legal 500 and Chambers as also Who's Who Legal in multiple disciplines. As a counsel and advocate, he has several reported judgments to his credit and has spoken at several dozen international conferences of the IBA, IPEBA, UAIA, etc. He is presently also Vice President of the Oxford and Cambridge Society of India. He has been the Chairman of the Law and Justice Committee of PhD Chamber of Commerce and Industry, and is presently the Chair of Expeditious Access to Justice and Contract Enforcement Forum of the Chamber. Who else is better to open up and the first session of today's webinar? Over to you, sir. Thank you so much for joining us.
Thank you, Bhuvnesh. I really didn't know my profile had been sent to you, so I'm sorry it was so long. That was not intended from my side. That's the only place you've got too much detail, and we don't have enough time for detail in this session. So I'm going to plunge into the deep issues that I think plague this system. And we're very lucky to have a fantastic panel with Justice Sikri. Judge Saab is heading our arbitrations. I'm very grateful to be on the same panel with him. It's a privilege, also with Justice Singh. And I haven't seen Justice Midha yet, but Mr. Diwan, thank you very much.
Justice Midha is joining, sir. He's having some connectivity issues. He'll just join in a minute, sir.
Well, thank you for this privilege, and thank you, Dr. Singh, also. Thank you, Mr. Agarwal. I think I have been accused by Justice Sistani of having an obsession with improving and speeding up justice in India. This is a project that we're taking forward for the IBA, and that's why I'm heading the Expeditious Access to Justice sort of task force of the PhD CCI. The state of the legal system, I'm sorry to say, is a difficult one, and that's putting it mildly. I don't want to belabor the point about how many cases are pending and how they have been adversely affected by the pandemic. We have seen a pendency increase from 65,000 to 70,000 in the Supreme Court, an increase from 47,000 to 56,000, lakh in the high courts. And in the subordinate courts, it's gone up from 3.7 to 4 crores. So you must understand that if we have technology coming in, the most important thing for us is to be able to use technology for speeding up the system. And let me say that we started in April 2020 with some trepidation about the use of technology. Video conferencing was the use of the name for Zoom. And when it first came in, I remember a session with the High Court Judge, Justice Narula, who very kindly agreed to be on a panel, then couldn't get onto the panel himself because of connectivity problems. And we had him through an MTNL line speak to 500 people who were all on the Zoom. And in those early days, we also had problems with people sneaking into the Zoom session and trying to corrupt it. We've learned to deal with all that, and technology has gone a long way in the courts. We have hearings almost routinely, Supreme Court, High Court, lower court, where we have ability to do what we couldn't do earlier. One of the big ones is that we can actually share judgments, share a filing that happened minutes before with the judge, show the judge where we are, show the arbitral panel where we are. And Justice Sikri, I have to thank him for being one of the first judges to mold the system around an arbitral tribunal that set forth on moving forward online. I think we jumped into online in early May 2020 for the first time, and the effect of that was proceedings that would have been stalled by the pandemic were not. On the other side, we've seen automatic adjournments given in many courts because of the pandemic, and that has increased pendency. So we need to see what has the pandemic achieved. It has achieved the use of technology through what used to be called only video conferencing is now called online hearings. It's improved the idea of recording of evidence. We've all come up with some amazing new technologies and systems to protect us from misuse of technology. Sometimes we've sent a physical person to the other side while everybody else sits online. Sometimes we've used a fisheye lens. Sometimes we've used transcription. Sometimes the arbitrators or the court simply asks the examined witness to turn the camera. But we are developing ways of recording evidence even online, and that didn't happen before. The pandemic has helped us to file and save many trees through multiple filings that can be done online without the need for photocopying, submission of documents. Thousands of pages that you used to print out earlier are now being sent through a link, through Google Documents, through shared online submissions that are on the cloud. The sharing of judgments has become easier. You can find judgments online, and there is less trepidation against seeing it on a computer, which I can tell you in 2019, it was unheard of to say to the judge, I'll share the judgment on a screen. So those things have happened, and there's movement towards e-filing in a very progressive way. The service of summons has become possible even by email. And then now we have the possibility of translation happening for judgments where people are not able to deal with everything in one language. They can use artificial intelligence for those aspects. So technology is helping us every day, and artificial intelligence will make a big impact on our lives over the next few years because of something very interesting. Once you can have online hearings, you can even have bots, that is, a certain type of computer, handle certain types of answers to technological hearings that involve, for example, traffic offenses. That will free up our magistrates and allow them to deal with hearings through robotized systems and reactions. We also have the opportunity of profiling, which is not yet available in India. So we have correctional offender management profiling, and this is a compass system that is being used outside India, and also public safety assessments of under trials to see whether they pose a risk to the public. And if you see this, it's almost something out of a science fiction movie, because you've got factors like current arrest, current violence, offenses, pending charges. All that comes into a computer database for each individual. It could be on the basis of Aadhaar, it could be on the basis of a PAN card number, and you find that about the human being, and then you're able to see whether he's a profile risk to being released before you grant him bail. So this kind of use of technology in the justice system is great. These are developments. The problem, my basic problem with the technology system is that it's not been put to full use yet. My complaints against the judicial system are that it's too little and not fast enough. Why? Because in 2017, we had a judgment of the Supreme Court where we decided that we would open the system to recording of to airing online. We would make hearings available online, and we would also use that system to go ahead with people being able to see Supreme Court hearings through recorded, such as YouTube and so on. There was Swapnil Tripathi judgment of the Supreme Court is still not fully implemented, and we need to implement it, not through the limited system of hearings, but also through access to the public and recording and being able to cite what has happened in the court. So that is one of the things that is lacking. The other thing that is lacking in this system, and which is costing us a lot of time and revisiting, is the fact that we are not looking at accountability either of the litigant, the lawyer, or, dare I say it, the judge. And I don't mean the Supreme Court and High Court as much as I mean the judges at the district court level need also to be monitored. What time do they arrive on the scene? What time do they clock in? What time, how many hours do they spend on hearings? And how many judgments do they deliver? I think we have a pretty good notion of how many judgments they deliver, but we don't as yet have in our system a means of appreciating the amount of time put in by a specific judicial officer as against somebody who is being able to generate the judgments, but not able to hear as many matters as are heard and disposed of. Our systems of accountability are still somewhat lacking. So these are the things that we need to improve on over the next few years. My view and vision for the Indian legal system is that it has a tremendous potential because we have so many lovely judgments coming from the high courts, the Supreme Court, that are moving in the direction of improving it. Justice Midha is on. I've read his judgment on proclaimed offenders from June 2021. It's an amazing piece of judicial work. And when you see that, you find a judge of a high court coming out with guidelines to the police for the future that always will improve the system. Justice Sikri, of course, I don't need to say what all he's done. So much improvement has happened in his different courtrooms in the Supreme Court. But we've seen it at every stage. There's an intention to improve. Unfortunately, there's not a cohesive sort of single path. And that needs, this unification needs to come with a little help from the government. And they have to understand that at the grassroots, we have some of the worst silly problems plaguing our system. What Justice Midha dealt with in proclaimed offenders was one tip of an iceberg. There are so many aspects of that that need to be looked in a little deeply. If you appreciate it, we have problems with 138 that plague the system. They delay so much of the trial court system, and they have been attacked by the Supreme Court with some band-aid applied to the amount of blood that's gushing out. But it's not been sorted out because there's no policy decision on it. Consumer cases are plagued by, it's meant to be, I think, decided within 2 months. It takes something of the order of 6 to 10 years to have a consumer case decided. So we don't have a system where we are able to deliver justice fast enough. And we are an amazing country when it comes to delivery of substantive justice through what we call infinite opportunities. And we need to change that. If somebody doesn't show up, he loses out. His opportunity is closed. These are things that are still not driven by our systems properly. And I think technology can aid that. I've spoken as quickly as possible because there was so much to say. And I think we all have very limited time. So I'm going to stop here. But I think I want to leave you with 2 thoughts. One is, I think there's a possibility of technology creeping across the whole system through an integrated system of e-filing that will be monitored by the center from the beginning to the end of a litigation. That will give us statistics. It'll give us a system of accountability, both for litigants, lawyers, and judges. And at the same time, yes, Big Brother will watch you. That will be maybe the Ministry of Law and Justice through a process of saying this litigation is taking too long. I mean, there are litigations and we have decisions of the Supreme Court, which we're very proud of, mind you, relating to the operation of the Hindu Succession Act before 1956, coming out in 2022. So somewhere there's something going wrong with the system that is not monitoring its litigation. Where are these systems going? And how can we allow that to continue for so long? So we need a centralized computer system which allows only e-filing. And the e-filing will happen, you select your court, whether it's the Supreme Court down to any district court, and you file your online petition, and you file your replies online, you file your rejoinders online in one centralized system, which no longer requires us to follow up on a physical process. The second aspect is the system becomes computer-driven. It monitors each and every litigation. If records get lost, no problem. They're already there in e-form. We need to move to that system for technology to take us there. And I think the pandemic has given us that excuse. Thank you. Thank you for allowing me onto this platform with these eminent people.
Thank you so much, Mr. Prasad. Undoubtedly, you've given us a very wide view of the benefits which the pandemic gave us. In fact, as regards to the e-courts or functioning through the virtual platform, as well as the issues which are currently, in fact, the entire legal fraternity is facing from the backlog of the negotiable instrument act cases, or so to say, the consumer cases, as rightly pointed out by you. We are taking in, as regards to the judgment of the Honorable Supreme Court, as regard to the live feed, which you just mentioned, it's very interesting. But now what portals like Bar and Bench and Live Law are doing, they are verbatim actually stating each and every word which transpires in the court, which they are actually doing it in the same manner what the Honorable Supreme Court actually asked, was planning to do. So yes, that is there in the trial courts. As we practice the negotiable instrument acts, some digital courts have come up, and all the filings have started happening digitally. So yes, there is some little improvement, but obviously there is a lot of scope in that sphere as well. So thank you so much, sir, for your time and your valuable suggestions and point of view. I would like to now call upon our next distinguished speaker, Justice J.R. Midha. It's actually a privilege to introduce sir. Justice J.R. Midha was appointed as an additional judge of the Honorable Delhi High Court on the 11th of April 2008, as a permanent judge of the court on 6th of July 2011. Justice Midha has been practicing before the Honorable Delhi High Court, Supreme Court, as well as the other court and forums, including the MRTP Commission, National Consumer Dispute Resolution Commission. Justice Midha was the standing counsel civil of the government of NCT of Delhi before being elevated as the Honorable Judge of the High Court. He has the most extensive career graphs from 1989 to 1992. He was also teaching at the Campus Law Central Faculty of Law, New Delhi. He has taught various subjects and the judgments, as Mr. Prasad said, are quite valuable to us. And thank you so much, sir, for joining us. We were waiting for you, and there was a network issues at your end. But thank you so much for taking out time and joining us, sir. Over to you, sir, for your valuable thoughts on the topic for the day. Thank you so much, sir.
Sir, please unmute, sir. Unmute yourself.
Thank you, Mr. Bhuvnesh. Honorable Justice Sikri, Justice Navaniti Prasad Singh, Mr. Amir Pasrich, and all the senior people from PhD chamber, Mr. Kuber Dewan, Mr. Sehgal, and Mr. Raman Agarwal, and Mr. Rashid Hir. I am thankful to PhD Chambers of Commerce for giving me this occasion to share my thoughts with you. Earlier also on one occasion, we had shared our thoughts on the subject. Sorry, I missed Dr. Jitendra Singh is also here on screen. I welcome him also. So this is a very interesting and alive topic in today's time. I had the occasion to preside over the bench when the pandemic started in March 2020 till 7th July when I demitted office. And my observation is that this technology has helped the judicial institution the most. Because of this technology, we have been able to not only work to the extent what we are working, we were rather, to my mind, the working further improved. And the biggest beneficiary of this technology system, the judiciary switching over to this virtual courts, is, to my mind, the biggest beneficiary is the lawyers, and the second beneficiary is the litigant. You see, lawyers in the physical courts, most of the time of the lawyers is spent in waiting for the case. Whereas when we turned over this to the virtual mode, then the lawyers were able to utilize their complete time. Whenever the case is called, they will join, and till that time they keep on doing their efficient working in their office. It also saved them from the travel time, traveling to the courts. Third, it also gave them an opportunity of appearing in 10 cities at the same time, on the same day. So, to my mind, the biggest benefit, that is why when in between, whenever the physical courts were opened, so the busy and senior lawyers had very great difficulty and secondly, many of them, they were operating from their hill stations or foreign destinations and still making good money. So this was a very great, to my mind, adventure for all the lawyers, rather the top lawyers and senior lawyers or busy lawyers in this system. Second beneficiary, even to the same extent or a larger extent, is the litigant. You see, now the litigant first, he can see what is happening in court. So most of the time, the litigant is himself also connected and he sees for himself what is happening. So he need not call up the counsel after the hearing that what happened. And then now he's able to see for himself what is happening in court. Secondly, the cost of litigation also came down. My understanding is that the same counsel fee, especially for outstation, the senior counsel going from Delhi to Bombay or going elsewhere, the physical cost of going and coming, now with the virtual hearing, the cost came down. So to my mind, it also improved the concept of access to justice. And again, from the point of view of delivery, the beneficiary is the judicial system also. Personally speaking for myself, I found that in virtual mode, the efficiency increased. We were able to, and the amount of time which was taken in arguments, that also reduced, because once it is in virtual mode and it is being seen by everybody, now from the lawyer's point of view also, the arguments became more responsible. So at times the irresponsible arguments and at times the repetition which happens in physical courts, that reduced. So I found that from that point of view, the time was also saved. And speaking for myself, I found the efficiency also increased. And particularly from March 20 till July 2021, there were some very heavy, high-stake matters wherein judgments, especially what Amir has mentioned, proclaimed offenders, that judgment required very lot of time, which to my mind, if the courts had been working physically from March 20 to July 21, it may have been a little more difficult, or it would have consumed more time to finalize those judgments because of the time required for the research work, for the study work, for that compiling all those works and then delivering some judgment with contained the guidelines. The judgment we discussed on the last time also, it was one of the main, you can say, problems which the society is facing. I'll just take 2 minutes, I think, since otherwise that was not the topic for today's discussion, but since Amir has already pointed it out, so I'll take it. You see, in Delhi, we have, I think, I don't remember the exact figure, but about 25,000 proclaimed offenders. People who have committed the offences, FIR registered, but they stopped appearing in court at some point or the other. So the court magistrate declares, or the sessions court declared that person as proclaimed offender, close the file. And police also closes the file. And that person who has now run away from the system, he is neither traced out, nor he has to now take bail, nor face the trial, nor face the conviction, nor face the imprisonment. And he will somewhere, and many times the concerned investigating officer is aware where he is staying. But then there is an arrangement between him and the accused. But that makes the society so much unsafe that the person who has committed the murder or repeated offences, and the criminal justice system, which starts with the registering of FIR, it comes to an end. So in that case, we have the High Court has laid down the guidelines that what steps should be taken for. Firstly, court also suggested that the assets of the accused should be taken in the first instance, so that immediately when you declare proclaimed offender, his assets can be attached. Once all the assets are attached, there are chances that the person will come up and surface. The number of steps have been laid down how to trace those proclaimed offenders. Anyway, this is not the topic for today. We'll reserve for some other occasion. But I'm more optimistic than Amir. Although Amir finally, after giving the good points, finally said this system is not working well. But I am more optimistic. To my mind, this system is working quite well, and it will improve. You see, even from March, when we switched over to the system in March 20, in 1.5 years also, or rather it is more than 1.5 years now, we are now touching, will be almost, it will be 2 years. Now, the system has improved there were so many roadblocks. There's so many, you can say, obstacles which we found in the system. So all those obstacles have been screened out. Things are today better than what they were 2 years back. And to my mind, the hybrid system should continue. And the hybrid system is the best system. And you see, with the improvement of this system further, to my mind, it will benefit all the stakeholders, the lawyers, the litigant, as well as the judiciary. And to my mind, I've completed my time, and we have very learned colleagues here, Justice Navaniti Prasad Singh, and we would like to hear Justice Sikri, who is my mentor and has always guided me, and he will throw more light on this subject, and we'll learn something more new. Thank you very much.
Thank you, Justice Midha, for such a wonderful talk. And in fact, you have touched all three important points in terms of the stakeholders who are actually the beneficiaries of technology and justice delivery system. The biggest benefit you said about the busy lawyers, it was an adventure for them. It was a good change for them. They became more tech savvy. Then second important stakeholder you mentioned about the litigant, because litigant can see actually what is happening in the court. And the most important thing is the cost of litigation has come down because of the virtual hearing, particularly for outstation travels, they have been cut. And more so, the biggest the beneficiary is the judicial system, because the efficiency has increased, the amount of time in arguments has decreased, and also there's a totally improved access to justice. So thank you very much, sir, for such a comprehensive talk. Thank you very much indeed. Now we have our next speaker, our learned Justice Navaniti Prasad Singh. Justice Navaniti Prasad Singh completed his schooling from Sindhya School, Gwalior, and he graduated and passed from law from Delhi University. He was enrolled as advocate on 2nd July 1980, and then he started practice in Patna and Jharkhand High Court on commercial, taxation, and constitutional matters. Justice Singh became a senior advocate in December 2004. On 6th March 2006, he was appointed as the judge of Patna High Court, and Justice Singh was elevated to the post of Chief Justice of Kerala High Court on 20th March 2017, and he died on 6th November 2017. So with this, I request Justice Navaniti Prasad Singh to kindly share his deliberations with the august audience. Over to you, sir.
Thank you, Dr. Jupitice Singh. Honorable Justice Sikri, Honorable Justice Midha, and other office bearers of PhD Chamber of Commerce. It's a privilege to be here once again on a subject which was quite dear to me, for a very basic reason, which probably none of you know. Digitalization, as introduced to judiciary, in fact started from Patna High Court. It was Dr. Bharuka, who was then a judge of the Patna High Court, who started the whole movement. And in recognition thereof, first he was asked to digitalize the records and the listing system of the High Court, of the Supreme Court. And as a judge of the High Court, he spent 2 months in the Supreme Court digitalizing the whole process. He was then shifted to Bangalore, and that is where he was given the charter to digitalize and e-movement in the judiciary from the grassroots level, that is the district court level, and integrating it to the Supreme Court. And it was Dr. Bharuka who did it. And he was then made the first chairman of the E-Commission for Judiciary. And that is how I was associated with it, being his chamber junior virtually till his elevation. So we used to work together at times. So now I will move from that to what the present problem is. Now everyone has talked about good things that will happen with digitalization of judiciary. But has anyone tried to assess the accessibility to technology across the board? Because kindly keep in mind, Delhi is not India. the Delhi High Court or the Supreme Court is not India. There are district courts in many rural areas which yet do not have proper electricity. What do you do with digitalization there? Majority of the lawyers have no access to laptops. Don't look at Delhi. Delhi is a minute part. The system works as a whole. The concept of slowest horse comes in. You have to speed up the slowest horse for the system to speed up. Otherwise, that one horse will drag you back. And that is exactly what is happening. Everything is being concentrated, talked about, discussed, implemented at the High Court level or in affluent cities. But no one thinks that judiciary starts from the grassroots, that is the district court. And how well equipped are the lawyers at the district court level to deal with such situations? Now, that is one thing which people have to think and do. Like you must have seen just last week, the Supreme Court issued advisory that do not get connected on mobile phones. Now, the reason is some of the lawyers, they don't have or they are not proficient with laptops or iPads, or they don't have connectivity in their office. So they have to step out on the road to get connectivity. And that is why they are using mobile phones. Now, you may have the best system, but if the technology does not come down to the grassroots, the whole thing is useless. It doesn't work. Now, that is one. The second, I would like to point out that it is not that it is now after pandemic that evidence was being recorded through video conferencing. Very few people realize that way back in 2003, that is almost 20 years before this pandemic, the judgment of the Supreme Court clearly laid down Desai's judgment that evidence under the Evidence Act, read with provisions of CRPC, could be recorded through proceedings in internet. There, one of the witnesses was in America. So that was way back in 2003. The first trial on internet was conducted of a person who was in imprisonment in Tihar jail at Delhi, and his trial was being conducted in Patna Sessions Court. Now that was, I think, even prior to this, 2003. The whole trial was conducted through internet. There was no issue of producing the witness or producing the accused again and again at Patna, because that accused was wanted in many other cases and different parts of the country. So technology was there. The problem is twofold. One, accessibility. The other, acceptability. People are not ready to accept it. Now, without boasting, I'll give an illustration. I argued a matter before the Punjab Haryana High Court, where a couple wanted their marriage to be registered. Unfortunately, the couple had got separated. One was stranded in England. The other was stranded in America when the pandemic started. They had been married at Gurgaon just before the pandemic. Now, neither could get their passport endorsed with the marriage because the marriage certificate was not being issued, and none of them could come back to India for that purpose. Now, the learned single judge said this will require amendment of the law, which the judges can't do. And the writ petition was dismissed. I appeared before the division bench. The division bench judgment is a path-breaking judgment where they said that now as we are having the cases being argued through video conferencing, what is the wrong in registering the marriage through video conferencing? And the judgment was delivered. That was challenged by the state in the Supreme Court. I appeared in the Supreme Court. The application of the state was dismissed. That judgment has now been used by Delhi High Court, the Kerala High Court, the Bombay High Court, all over the country, that yes, it can be done. Now see the amount of time that is saved. Now people have to get used to this idea, accept that yes, this can be done, this should be done. And only then people will start working. Now, I may just say that people who do not accept this, because there are still a large number of people in the judiciary who believe that virtual hearing is no good. It has to come down to physical hearing. They're not ready to change with time. They still maintain that virtual records, no good. The whole thing is because they are not apt, they are not adapting to it. I'll give two illustrations. One, everyone will remember Kodak. The films, camera films. Now, when the technology was changing over to digital technology, somehow Kodak, which was the front runner in the film production, they did not agree to change over. What was the result? In 5 years' time, Kodak, which was one of the leading companies, went into liquidation. Similarly, if you remember the typewriters, before Godrej came in a big way in India, what was it? It was always Remington. Now, when electronic typewriters came in, Remington refused to change. What happened? 5 years down the line, the company wound up. So we have to accept the change, make it accessible, and results will follow. Now, it was mentioned that this technology may help in fast delivery of justice. In my view, that would be only very minimal and marginal. It's only the procedure that is being replaced. Fast delivery will only come when we have adequate number of forums to ventilate our grievance. It's as simple as the traffic between two cities goes on increasing with no increase in frequency of trains. What will happen? The litigation has gone up hundreds of times. But are there enough judges, courts to deal with it? They are not. And this technology is not going to answer that. One of the speakers mentioned about 138. Now, what did the Supreme Court say? The problem of 138 arose because the legislature never carried out an audit of what the legislative impact on judiciary would be. They made a legal provision, but they didn't back it up with the judicial appointments. The result is, in Delhi, each magistrate is having about 10 to 15,000 cases just of 138. It's humanly impossible for him to deal. By making it electronic, You can't speed up the thing. Because after all, the judge is only one. So digitalization will improve, but it will not speed up. So we have to get our priorities right, make it accessible, acceptable, and then proceed. It has a lot of advantage. It saves a lot of paper. It saves a lot of time. Now people are arguing that once the pandemic stops, forget the video conferencing or VC hearings. I don't know why. We can continue with hybrid. It will only help. On every date, a witness is supposed to, accused or a person is supposed to give hazari in court. Why can't he give a e-hazari? Carry on with his work wherever he wants to. Now, those innovations have to come about and has to be accepted at all levels. I think I have taken my time. I have just brought to your notice certain things which require to be looked into. Thank you very much. Thank you.
Thank you, Justice Navaniti Prasad Singh, for a very, very pragmatic talk. In fact, you also told about the problems, and some of the problems like accessibility is definitely one of the things of concern. And it's also heartening to know you said that this digitalization started from Patna High Court, so it's a news for most of us. And I'm sure that the way it has taken, probably in a year or so, we will see a big boom, in terms of using technology in justice delivery system. Thank you very much, sir, for your talk. Thank you very much. And now we'd like to invite our keynote speaker, Justice Sikri, and we have a brief profile of Justice A.K. Sikri. I just read it. So Justice Arjan Kumar Sikri, born 7th March 1954, is an eminent jurist and a former judge of the Supreme Court of India. He was sworn in as a Supreme Court judge on 12th April 2013. Earlier, he had served as the Chief Justice of the Punjab and Haryana High Court, and he retired as the senior most puisne judge of Supreme Court of India on 6th March 2019. Presently, he is an international judge at the Singapore International Commercial Court, SICC, Singapore Supreme Court, and he was sworn into the post on the 2nd of August 2019 by the President of Singapore. He is also the chairperson of News Broadcasting Standards Authority. Justice Sikri has an excellent academic record. He stood third in the merit list in higher secondary from CBSE Delhi. He completed his BCom honors from Sri Ram College of Commerce, Delhi University in 1974. And he completed his LLB from Faculty of Law, University of Delhi in 1977 and won the gold medal. He also completed his LLM from the Faculty of Law, University of Delhi. Justice Sikri was enrolled as an advocate in 1977 and he started practicing in Delhi. He had specialization in cases, labor service matters and arbitration matters, and he was a counsel for numerous public sector undertakings.
Leave it.
Okay, sir, such as a glorified sir resume. I just want you to go on and on. Thank you very much, sir. All yours, sir, now. Thank you.
Thank you, Dr. Jatinder Singh. I should thank you for inviting me also on this webinar, which is really, I mean, it's an idea whose time has come, if I may say so. And therefore, PhD leading the discussion on this aspect is really a welcome move, and I congratulate PhD as well. My greetings to Justice Navaniti Prasad, Justice Midha, Mr. Pastrich, Mr. Raman Agrawal, and Bhuvnesh and Kuber Diwan. As I said, that the topic is not only interesting, but it is challenging as well. Most of the speakers earlier have almost covered the entire spectrum and touching upon different aspects of the issue involved. If I may say so and start with the theme itself of today's webinar. You have labeled it as justice technology need of the hour. So when we talk of justice technology, what do we mean? So the two words which are very important, both the words, one is justice, other is technology. So therefore, technology for justice system. And when we talk of justice system, let me say so in the beginning itself, that we are not talking of the judging only in the courts, because that would be a very myopic view. Because and I'll delve upon that, and I'll try to highlight more on that. Taking first the two very major comments of Justice Navaniti, he said about start of digitalization, etc., Patna High Court and Justice Baruka, etc. I know about all that, and it was Justice Lahoti's time that he was brought here as he was the Chief Justice, Justice Lahoti, and he was brought here. And but what he mentioned was that, look, digitalization may be good, but then problem is that Delhi or metropolitan cities are not the only places. If we have this digitalization naturally in the courts, etc., then we need to spread not only the technology but the awareness thereof also in suburbans, semi-rural, semi-urban or rural areas, also in those courts. I'll come to that. Now, of course, it is a challenge, no doubt about it. And the second thing which he stressed upon was about the use of technology, and as he said, that evidence, recording of evidence, which started in 2003, and the judgment of Justice Desai, which he mentioned. And he also mentioned that, look, technology can take care of the areas only marginally, and there are other measures also which need to be addressed if we really want to make our justice system robust. This is a valid point, but then much can be said on the other side also, to which I will come. And because why I want to start from here is when he says that it can take care of the areas marginally, and other things which he talked about, other alternatives and more judges, etc., and more courts. No doubt those are required. But I would like to differ here with Justice Nanavati to say that it will take care of the areas marginally. My answer is no. It may even bring a revolution insofar as tackling of the areas is concerned. And that would be my endeavor when I talk about justice technology. And therefore I said in the beginning that when we talk of justice technology, it is not the technology only limited to courts we are talking about. And therefore, in the beginning, I will like to take more time on that, which Mr. Kuber Diwan had mentioned about ODR. And we have ADR, we have ODR, and I like to discuss that aspect in some little detail. So I want to give, as far as justice technology is concerned, a 360-degree view of that, and how it has to be perceived, and how it has to be propagated, and how it should be introduced in our system. Mr. Pasrich mentioned about the areas, no doubt about it. And because of the pandemic, COVID pandemic, the areas have also increased. He has given those figures. We know that conflicts arise in a society. Any society, conflicts are bound to be there, disputes are bound to be there. But it is in the interest of the peace in the society. It is in the interest of the two, the stakeholders who have come to the court, that the cases should be decided as expeditiously as possible. And not only that, it is also important, which Justice Midha also mentioned, that insofar as consumers of justice are concerned, they should be, I mean, the delivery of justice to them should be affordable as well. As he mentioned, many because technology will be cost effective, etc. So, but these are very important parameters in any justice delivery system. So, in this behalf, what I would say that I come to this when I am talking of justice technology. Yes, in the courts, in the first instance, it has to be, technology is to be introduced. Mr. Navaniti, I again repeat, had mentioned about recording of evidence. He had mentioned about that the technology was there, which was introduced in Patna, etc. Of course, it was there. The Indian system, judicial system, ushered into computerization almost 17, 18 years ago, or maybe 20 years ago, no doubt about it. Computerization had been taking place, and with this, we had many advantages of this computerization over a period of time, like which was stated by Mr. Pasrich. I would again say about the e-filing, the giving of the stamp duty or the court fee, etc. Also in e-stamping is there. There's a service of summons, etc., which is now in e-forms. Then electronic boards, which he mentioned. I still remember before these boards were not there, and in the court, in the high court sitting there, we will, if you have a case in a court which is on the original side, in the say on the ground floor, or on single judge matter on the first floor, or division bench on the second floor, some of the, and you may have cases everywhere. So which case is going on in which court, you will keep running up and down. Oh, my case may not have come, turn may not have come. But when these electronic boards were installed, we could see which case number was going on in which court. So we could sip a coffee in the canteen and keep on finding, oh, my case may reach after 10 minutes, 15 minutes. I have that time. And so, and those who have chambers in the high court, like I had, and where I know that it may take about 1 hour or so, we could sit in our chamber and do that work also, which of course, just as Midha said, in a different manner, that this because of this virtual mode, how that has been to the advantage of lawyers. So these were what I'm trying to say, that such measures were there earlier also, and which had been going on, and there has been a progress about that. Mr. Pasrich mentioned about, he said about the integrated e-filing and monitoring thereof. We have integrated e-filing for quite some time. Yes, the monitoring in the manner in which he suggested is a very good suggestion that may not be taking place, but it was more than 10 years ago, like in Delhi High Court, and that has happened in most of the high courts also. Right from beginning, when the case is filed, on which date it is filed, and what is the position today, you can see each and every step. When that was filed, if there were objection, when it was taken back, when after objection it was refiled, when the process fee was given for service of summons, when the other side filed reply to that, when a particular application was filed, when the order was given, and all entire order sheet, everything was available earlier as well. There's no doubt about it. Without saying much on this, that information of all the cases were available. There have been attempts on the part of the judges based on this technology of doing case management, more particularly grouping of cases. I give you one example. I still remember there was one excise matter, and the judgment was given by the spate of petitions were filed challenging one particular provisions of the excise law, and stays were granted. One petition came to be decided by the Delhi High Court full bench. I still remember, headed by Justice Satcher, way back in 1989 or so. And other cases, they kept pending. I mean, because there were no grouping and there was no computerization. And when I was sitting with Chief Justice Sinha in 2001 or so, we decided about more than 150 cases, which should have been decided along with that case in way back in 1989 or maybe 83, I think. So they kept pending. But this technology has helped us in grouping of those matters so that all matters can be listed. If they are involving the same question of law, etc., they are all decided. So these are the advantages of computerization. But as I said, and as Justice Navaniti said, this computerization was going on. What pandemic or COVID has taught us, about which we are discussing today, the automation has now converted into transformation. It has led to transformation of the technology, which was not there earlier. Earlier, technology was only seen as facilitator. But now we know it can transform the entire justice system. And that is what we are discussing today. And how it can, I tell you, and it has been said by many speakers earlier, but there's a very interesting book by one Richard Susskind, and it is title is The Future of Law, and he talks about this technology. And if I may tell you, and because of paucity of time, I won't be able to say much about it, but what he says, one passage I'll like to read, and that is what when technology comes. Think then of a society, one that is carpeted in fiber, where everyone is connected to everyone, and each has immediate access from the home to guidance on most topics. And this guidance is presented in wonderfully graphic and easy to use form. Indeed, most users will essentially be speaking to their televisions when they want some information. Consider that this resource might indeed become the natural first port of call for the majority of people. In that context, can we honestly expect that legal service will continue to be delivered in time-honored fashion, though one-to-one, face-to-face consultative advisory service for which people are charged by the hour? I think not. But before I offer some rather specific predictions and recommendations, I believe it is helpful to take a step back and consider that in theory and in principle is possible in law in coming decade in the light of the advances in IT just outlined. And what he says, what is going to be possible, and I will only tell you give you the headings only where he has described this. Lawyers and judges specifically, Justice Midha said about the advantages to lawyers, about the online hearings and advantages to litigant and even judges. What he says, there is going to be new international dimension with a global information infrastructure in place. Today, what is happening in other courts in other countries, what is being argued, what are the judgments which are given, there's all available on web. You can have access to all that. And so this is going to be a very, and it is already, we are reaping the benefits. At the same time, the international law of cyberspace will be there, virtual legal teams. Now, I have done few cases in international arbitrations. I know where the teams, legal teams, because one hearing which finished about in December, there's one party from China, one from India, lawyers from Singapore, lawyers from England, there are experts from Spain and Australia. All we worked on it, without going to one particular place, we could hold the hearing, evidential hearing, and thereafter the final arguments on virtual mode, everybody sitting, 3 arbitrators, me from India, another from Australia, and third from UK. And it's not only we, what I'm saying, virtual legal teams, the legal teams, because Indian law was involved, UK law was involved, Singapore law was involved. So the legal teams also were, the lawyers in these, from all these jurisdictions, they didn't have to come together. They were virtually connected with each other and were, giving their own inputs on those virtual calls and the virtual meetings with that. That is what he's saying. Automated document assembly, you can have that. Legal diagnostic system, virtual legal libraries, which would be there. Today, if you know, there's all the national law schools, their libraries are connected with Supreme Court library. Anybody wants to have any benefit from any book, these are all digitalized. So these kinds of benefit which may be helpful for the justice system. And judicial decisions on internet, which I have already mentioned. And it will provide distance legal learning, unified court management, which I have already said, electronic transcriptions. Now the transcription that like you are recording this, the matter which is being heard, everything is recorded, transcription is going on, and in the evening you can get to what each lawyer argued and each and every line, what each witness said, each and every line, what he said, and in the cross-examination. So this is the advantage of technology. And I think here I may say the first point, which I said, that technology in this sense is not going to help only marginally, but it is going to help in a big way. And I have now up to now touched about the court system. But then when we talk of online, we talk of technology, it is the ADR system as well. Arbitration is going on with a big, and one example I have given. So therefore, when these cases can be decided online and with so much of cost, saving of cost and saving of time, etc. And they can be speedily done. Same applies to mediation. Of course, I may say in some cases it is possible, particularly in mediation, that when the mediator is trying to settle the matter, one-to-one hearing, in-person hearing may be necessary. But then we can have this kind of hybrid system with Justice Midha pointed out. And what is further important, which of course Mr. He had mentioned who is the Mr. Kuber Diwan. He had mentioned about ODR. Now, what is this ODR? I like to take 2-3 minutes only on this ODR. When we talk of ODR, online dispute resolution, of course, online courts we are talking, online ADR we are talking, arbitration. But another important facet of ODR which is to be seen, which he had touched, that there is going to be this online dispute resolution, some kind of category of cases which would be given as per ODR to the private agencies to decide those cases, which is very important aspect, which is already tried in many countries. I would only say that look what happened because of this COVID, and this caught the attention of Niti Aayog in India also. About one and a half years ago, there was precisely, I tell you, in June, I think 2020, they conducted one webinar on that, where judiciary participated, all ministries participated, and stakeholders participated. Thereafter, a committee was set up. Incidentally, I was made chairman of that committee, and we have given that report on ODR. Now, when we talk of ODR, and there are few types of cases which are apt, but what is to be seen is, and that is very, very important in today's date, is that, look, the justice, whether it is a service or the justice is a sovereign function. Only a sovereign function and only courts can do. I think over a period of time and in this millennium, it is realized that justice is a service which is to be provided. It is not necessarily a government function or state function, I would say, in that where judiciary is a state organ and it is a sovereign function, it is called. But justice is done through the means of arbitration also, through the means of mediation also. And therefore, it is now realized there are few types of cases, particularly consumer cases. Mr. Pastriche mentioned that few cases are taking lot of time, 8 years, 10 years. Now, how it started? There are, if you say eBay came out. Now, if there is a dispute of some product purchased from eBay, they have their own system. Will try to, because suppose a product of 5,000 rupees or 10,000 rupees I buy and it is defective. Can I go to court for 5,000 rupees? I would be spending 50,000 rupees in that. So why not such disputes on ODR given to these private agencies? And artificial intelligence is advantage of that is taken, and which may under certain circumstances can provide you ready-made, if the algorithm is of that nature, can provide you ready-made answers for that. And as I said, because of time doesn't permit, I can't say more, but I can tell you, I think if you go on Niti Aayog website, you will find that report on ODR, which we presented after this work is already over. And if I take on this ODR itself, what it is, it will take 1 hour to describe that. So that is not the time. But what I'm trying to mention is that much of the work would be taken care of through ODR system. It is now after the pandemic, we have highlighted the cases of negotiable instrument or the dishonor of checks, rent, because many are not able to pay that rent, landlord-tenant disputes. These are bound to arise. On some commercial litigation on the whether these conditions were like we call act of God, or whether that would apply or not. All those cases are going to come, but ODR may help and may take much of the burden, including that challans which Mr. Pastriche mentioned about, traffic challans. So therefore, if ODR is implemented, this online justice is implemented, and it is done in a proper manner, it is going to help us. I agree with Justice Navaniti when he mentioned about accessibility and acceptability. In this report also, we have mentioned what are the challenges in India. Of course, one good thing which we mentioned is that India is ready for ODR. Judiciary supported, ministries have supported, stakeholders have supported. But then what we need is that still there are challenges of, that digitalization has to be done at all levels. So we talked of these challenges, structural challenges, that is such as lack of digital literacy and digital infrastructure, behavioral changes such as lack of awareness and lack of trust in ODR, and operational challenges such as difficulty in enforcing ADR outcomes, etc. So these challenges are there, but yes, we have to now over a period of time try to overcome these challenges and move forward. And even when in the courts we go back to normal times, for many kinds of benefits which are there, we should have, as earlier speakers also said, hybrid system should continue. Thank you very much.
Thank you so much, Your Lordships. Your Lordships session has been most certainly a lot. We have gained a lot from it. It is not only digitalization or of the court hearings, but most certainly very, as rightly mentioned, a very vital part, which is ODR. And we sincerely hope that the report submitted by Your Lordships and the entire committee is taken up in its true spirit, and as soon as possible, it should be implemented in the right spirit. We are so grateful for your time, Your Lordships, and the valuable suggestions and points pointed out by you. It is very well taken, and we will try our level best. In fact, in our representations which the PhD Chamber of Commerce continues to send to the Ministry of Law and Justice, we would most certainly include that. And in fact, we will go through Your Lordship's report and would most certainly take certain pointers from there and mention in our representation. With Your Lordship permission, I would like to welcome Mr. Raman Agarwal. Mr. Raman Agarwal is a serial entrepreneur, a government advisor, a professionally qualified chartered accountant, and a philanthropist with 32 years of experience. Successfully created 3 large businesses across knowledge industry, technology industry, infrastructure industry, with shareholders' wealth of $100 million. One of the relevant businesses, Aaron LPO, is India's largest legal process outsourcing company that provides services to AmLaw 100 firms and Fortune 500 companies since 2006 with team of 200 attorneys. Mr. Agarwal has a wide experience, and he's been an advisor to the ministry, to the member secretary, Punjab Prisons, member of task forces of Punjab Reform Commission. The list is endless.
Yeah, it's okay.
He is also the founder of the Jupitice Technology Private Limited, a technology company that focuses on e-commerce for justice services across the globe under the private justice system. So your lordships had mentioned about the ODR. I think so. Mr. Agarwal has thought about it, and he's the person who has the entire system ready to take off. And we are so grateful for Mr. Raman Agarwal to partnering with PhD and helping us organize this webinar today. Over to you, Mr. Agarwal. Looking forward to a much more learning experience through your presentation today. And thank you so much for your time, sir.
Yeah, thank you very much, Bhuvanesh. Thank you very much, Dr. Jitendra. And thank you very much, Honorable Justice Sikri, Mr. Singh, and Mr. Midha. And thank you very much, Amir Singh and the Office Bureau of PhD. I totally agree with Justice A.K. Sikri, because he rightly said the justice and technologies, these are two different things. And since I have been long experience in running the largest legal process outsourcing for Google, Yahoo, HP, and we have been providing the litigation support through technology from India and a team of over 200 lawyers. So we have been working on largest technology platform for e-discovery solutions. So because in US, 70% of the litigation cost is because of the e-discovery, because of your discovery and inspection, the process in the litigation. So let me start with certain things, because we are the first justice technology company in the world. We rather given a birth to a new space called Just Tech in the technology sector. I always say justice includes law, but justice is an independent function, because justice can not only be delivered through the articulation of law, it can be delivered through the mediation and other processes as well. So I always say justice is separate. So we basically have developed the world's first justice technology platform. And when I say the justice technology platform, so we have basically designed and developed the world's first foundational infrastructure and the capabilities. So when I say the foundational infrastructure and capabilities, which we have already invested over 25 crores in making this foundational infrastructure and capabilities, where that includes the technology, means we have developed in-house over 50 plus software applications, even the video conferencing system as well, which has been seamlessly integrated into a single platform. And then we have the knowledge and we have the skill. We have created the world's first online justice marketplace, where we are now aggregating arbitrator, mediator, conciliators, and lawyers from across the globe, having diverse expertise and multilingual capability on a single platform, so that the disputant can come and connect with them and can find their own lawyers, their own arbitrator, mediator, conciliators, according to their budget, according to the expertise, according to the languages, whatever we basically have given various kind of parameter based on which the disputant can take a well-informed decisions to hire, appoint, negotiate, formalize their relationship, make payment, etc., everything. So what we have done is, we have created three things. One, we have created a dispute resolution platform. So it's basically a complete dispute resolution ecosystem, where we have created various digital codes. Like, say, for example, we have created a ADR, digital ADR code, where not only the online filing, so any disputants can come on this platform, they can draft the entire pleadings, their statement of claim, the statement of defense, everything on a single platform. and then they can file it. They can all the hearing can be held on the platform, and they can upload their evidences. They can examine witnesses. They can cross-examine witnesses. They can make the full argument of the case. I mean, the entire end-to-end process can be performed. As you know, justice is basically like the knowledge is not found in the school, or the health is not found in the hospital. See, justice is an outcome of a process. So it is a service. So we basically have not only digitized, our focus was not only, as Justice Sikri said, we have switched from automation to transformation. So this is exactly what we have done. We have not only digitized the paper-based processes, we have not only done the automation of the processes, we have done a complete transformation of the justice system, not for India, for across the globe. All the common justice system or the civil justice system, all the processes basically now they can perform end-to-end process on the platform. Everything, every aspect of the justice system can be performed over there. And similarly, like what you said is, and then this system has been further powered by the artificial intelligence and the blockchain. Like even for a layman who, like Justice Sikri said, for a smaller dispute, say 1,000 rupees or 5,000 rupees, how this dispute can be sorted out. So even for a layman, we have patented our what you call as a digital human called Saya. So Saya is a human technology, is a artificial technology where any layman can come on this platform. They wanted to draft their complaint. The Saya will ask few questions, systematically few questions, and based on their questions, they will automatically draft the complaint within himself and then can file the complaint on the platform itself. So the entire system, the entire dispute resolution, whether it is a judicial system, whether it is a quasi-judicial system, whether it is an ADR mechanism or whether it is an ODR mechanism, all the four type of mechanism basically that can be performed on this platform. And through the blockchain system, we have tried to ensure the immutability and so that the document which has been filed on this platform that can never be altered, because the blockchain is such a security which ensure the 100% safety of the document and then non-reputable. Even the person who's filing the document will never deny that that document has never been filed. So all the kind of process which is required for the delivery of the justice, that we have basically made that platform. So the point is not today that what we are doing for today. This is one aspect that we have the pending case. Like you said, there are 4.5 crore cases pending here. And there are 500 crore people out of 750 crore people, they have no access to justice. And every year 100 crore disputes arises across the globe, and 3 to 5% of the global transactions convert into disputes. As Justice Sikri rightly said, everything has a conflict. So in human being, we have three things. One called the relationship. We build up the relationship, we do the transactions, and we do the innovation. So in every relationship, every transaction, in every innovation, there is a dispute. Like say, for example, e-commerce disputes. eBay sells one car, one pair of shoes in every seven seconds, and the whole volume of eBay per day is equal to the volume of Nasdaq. So this is the kind of explosion that is going to happen. So this is one part. We should not only be concerned with our existing system, existing pendency. How about another pendency which is going to be exploded by the e-commerce business? And the biggest challenge for us today is, because today we have three kind of people. I can categorize three people. One is called the baby boomer, second is called the immigrants, and third is called the digital native. So baby boomers are the people who are the old people who had never took birth in the a digital age, so they have no idea what actually is digital. So they can simply work on the mobile. And secondly is the immigrants. This is people like us who lived in a traditional age and we're also living in a digital age. And now the people who were born in 2000 or 1990 who are basically digital native. So we are building a new society now. We are building a new society in the cyberspace. Today, 2/3 of the global population is on net. The people who used to spend only 2 to 10% of the time on the net, now they have switched over to 40 to 50%. And in the next few years, it is going to be 80 to 90%. So the new society, which I call as an online society and digital society, their way of communication has changed from synchronous to asynchronous. Their way of living life, their way of living, doing business, everything has changed. And they live their life by their own rule. So are we ready to make the justice delivery system for the digitally native people? Because they are born with the iPad in their hand. Do you think they would be familiar and would be able to conduct these kind of dispute resolution process, which are paper-based or which we call as a virtual court? I always say virtual court is altogether a different ballgame. Even the Supreme Court also in their latest report, e-vision document, even they have shifted their vision from virtual court to the digital court. See, virtual court is a very, very limited utility. So digital court is something which is complete in itself. So right from the while sitting from the comfort of your home, you can draft your case, you can file your case, you can track your case, you can upload your evidences, you can conduct the arguments, you can do everything, every steps, every task, every stages, and every event. And most beautiful part is not just that you're doing it, you can also track it. All of your time events, everything is logged on there. And thereafter, with the database that what we are creating, we can have the insight from those database and we can interpret those database and we can create new capabilities from the database. Today what we are doing, we are using WebEx, we are using WebEx, we are using Cisco's WebEx, we are using Zoom, but we are not understanding all those data are lying in their applications, are lying in their server. So what we have done is we have from the scratch, we have developed every application in-house. We have developed 50 applications which can perform end-to-end functions, and every data will remain within India, within our platform, or it can be hosted in the government. And those data are so well structured, which can be used for developing a lot of AI applications and other capabilities, which basically were not conceivable in our traditional system. So in short, what I can say is the entire justice delivery system, to transform that, we were supposed to have a complete ecosystem and complete foundational infrastructure to do everything on the platform. So it is not only that we will be doing everything. Since it is a platform approach, we have also adopted an ecosystem approach. And tomorrow somebody has an expertise in contract drafting. So that contract drafting would also get integrated with our system, and you can draft your contract on the platform, negotiate and sign the contract. And tomorrow, because contract become the source of dispute, so tomorrow, if the dispute arises, then that contract surrounded by all the interaction and communication can be retrieved, which basically can be used for the purpose of your arguments and for the purpose of your references and everything. So this is just a small discussions on an overview about our justice platform, which is basically end-to-end justice platform. It is a marketplace. And regarding Mr. Singh's point was the accessibility, and he's rightly said there is a lot of two challenges. One is the acceptability and the accessibility. So when I say the accessibility, it is not only the availability of the resources. So accessibility, in my opinion, has three components. One is called the awareness of your rights. So I am accessible to justice when I'm aware of my legal remedies. Number two, the availability of the resources. And number three, the affordability. If the system is not affordable, then I won't say that I have an access to justice. So all this access to justice, so for doing all these things, we have created three functions. One, we created a platform which would give an access. The cost would be less because the kind of resources that we would make available, which would be gathered from across the globe, which are complement to each other, like because all the people would be more competent on the platform, they can negotiate their fees, and they would have an access those people, those talents which were not earlier visible anywhere. So we have created the structured database of all the ADR practitioners, lawyers, and dispute resolution professionals, so that anybody can choose their own professionals on the platform. Third, we have also created a legal empowerment application called Dialogue. So this Dialogue is again powered by our Saya, which is an artificial intelligent worker, where for any dispute, if you are, so it would be a sort of a my pocket lawyer. So if you are, say, traveling, you have some accident, some disputes somewhere on the roadside, you have no idea what are my legal rights. So you can simply dial, and within 60 seconds, so you have two options. Either you can interact with the artificial intelligence agent, or you can connect with our lawyers, with a bunch of lawyers who would be available 24/7, and you can ask your legal remedies, your legal rights, your obligation with that particular dispute that has arises on the way when you're, say, for example, going to Delhi. So we are not only legally empowering them, we are also giving the solution to resolve the disputes. So this is a overall view of about the Jupitice, and we have just launched, and we have also applied to the. We have also been made a lot of proposals to the Ministry of Law and Justice for rebooting the Indian dispute resolution ecosystem, and we have also made the presentation to the APEC countries, and they have invited us. They are interested to collaborate with us. They have invited us to make these presentations to all their 21 country members for the ODR mechanism, because we have created the world's first smart and intelligent ODR mechanism. And we have also partnered with the Haryana RERA, and we have created a RERA digital court. And as Justice A.K. Sikri said, that there are certain things which can also be resolved by the machine. Like in case of RERA, there are only two relief which the complainant has to take. One is called either he wanted to take the possession, or he wanted to take the refund, or he is keen to take the possession and enjoy the interest till he doesn't get the possession. So these are very selected kind of the relief they want. And as per the discussions with the chairman, we could see that 80-90% of that process can be sorted out by the machine itself, because there is no merit required in these kind of cases. So there are certain kind of a dispute resolution which can be more assisted by the machine with the help of course, there is a fair balance between the judgment, the human and the machine. So we have taken into consideration all those aspects and created a very smart and intelligent justice technology platform. And where now we are giving various kind of solution and services. And this would not only increase the access, but would also simplify and make the justice available at the doorsteps of everyone across the globe. That is the whole goal and vision of mine.
Thank you. Thank you, Mr. Raman. In fact, whatever has been discussed in terms of challenges, you are providing most of the solutions, and we hope that the systems become more affordable so that it has more wide-reaching, ramifications for masses at large. Not only, sort of restricted to few elite class, but definitely, because unless we talk about the last mile customer, then only we can say we are having systems that are highly inclusive in nature. Thank you very much for your talk. Thank you, Mr.
Thank you very
much.
Now
with this, I'd like to invite Mr. Rashid Dhir. Mr. Rashid Dhir is the co-chair of our New Delhi International Arbitral Institution, PhD CCI. I'll request Mr. Rashidi to kindly give the concluding remarks and vote of thanks. Over to you, sir.
Thank you, Dr. Singh. Good evening, everyone. Thank you for such an informative and insightful debate on the importance of technology in delivery of justice. While there are many things that are wrong about COVID, there is always a good in every bad. COVID has forced us to think about things we procrastinated on earlier. COVID has catalyzed the debate and forced the use of technology to our judicial system that was busy with its own archaic systems and world. There is no doubt that accelerating adoption of technology is a win-win for all. As Honorable Justice Midha said, it is good for all stakeholders. But as Honorable Justice Singh pointed out, the problems of accessibility and acceptability. As he said, technology is not a substitute for development of infrastructure. Honorable Justice Sikri articulated it well by pointing out that it is not technology, but automation, which is transformative. Since the opportunity is well defined, we have entrepreneurs like Mr. Agarwal who have found it worth their time to innovate, to bring technology and accelerate adoption. But let's not forget Mr. Pasrich's point about technology is certainly the way forward, but not a substitute for accountability and responsibility in delivery of justice. So I think it was a very well debated topic, and certainly there is a lot more that needs to be thought through in the adoption of technology in our justice system to accelerate providing justice to all. With that, I would like to, on behalf of the Chamber and New Delhi International Arbitral Institution Committee, I would like to thank our distinguished speakers, Honorable Justice Sikri, Honorable Justice Singh, Honorable Justice Midha, Mr. Raman Agarwal, and Mr. Amrik Singh Pasrich for taking out the time from their busy schedules and enriching the session today with their valuable thoughts. I would like to thank the PhD Presidium for the opportunity to organize this session. We look forward to your continued support for organizing more of such sessions on relevant contemporary issues. Lastly, I'd like to thank our fellow attendees for joining us today, and we hope you found the session informative and useful. Wish you all a pleasant evening ahead. Thank you.
Thank you. Thank you. Thank you. Bye-bye.
Thank you.
Thank you.